Okay, welcome to Chapter 10. This is our ongoing series. We've actually got 15 chapters to cover, so we're two-thirds of the way through when we're done with this. Again, this is based upon Criminal Justice in Action, 11th edition. Publisher is Cengage Publishing, and the authors are Gaines and Miller. These lectures are being recorded in June of 2022. Shortly after our pandemic lockdown end, and we're going to be looking today, we're in the middle of the book, we're looking at the court systems, and we're going to focus today on the criminal trial, which is chapter 10, and we've got a picture there of an ongoing court room. Apparently a defendant in a wheelchair is being represented. I would assume that that is the defense counsel standing next to him at the podium, and then at the far podium is probably the prosecutor. You can see the judge up there, the man with the beard, and then you can see the bailiff, or actually there's three bailiffs visible. They're providing courtroom security. There'll be a clerk of court sitting next to the judge, and I imagine, although I'm not positive, that that is a court reporter to the right with the glasses. Okay, so let's take a look at some questions. Again, I try to start all these lectures by asking you to think a little outside the box, to question what you're being taught, to explore what you're being taught. So here are a few things to talk about and think about as you go through this chapter. 1. Does a presumption of innocence exist, and should it exist if it does? Of course, in the United States, the stated theory is that all men are presumed innocent until proven guilty. But sometimes you can fairly state that a society or an organization may say something is true when in fact it is not. So the question, I think, is fair to ask: in our criminal justice system as it's actually applied, is there truly a presumption of innocence? We'll examine that question a little today. Also, should it? Is that the right initial position to take? I'm not saying you necessarily take a guilty position, but should you instead adopt a neutral position? Should all evidence be heard? This is one I get from students quite a bit. I get a degree of pushback where they say, and I think there's a degree of logic to be made here, a logical statement to be made here. If you're keeping the person making a decision ignorant of some fact, how can that possibly help him make a decision? In fact, is ignorance of any fact or opinion more helpful in making the right decision? I think it's counterintuitive to say, yeah, keeping someone ignorant makes them make a better decision. But and I hope I can demonstrate to you that perhaps, just perhaps, it is good to be ignorant about certain things when you're making a decision, or rather the adjudicator in trial. The last one is one I had a little bit of fun with last time I taught this class, so I thought I would include it in these questions, is: after a wrongful conviction, should those who make mistakes be punished? Now, you will rarely hear of a prosecuting attorney getting in trouble for a wrongful conviction, and even rarer, judges getting in trouble for it. Specifically, I'm thinking of, in that case, there was a couple Pennsylvania juvenile court judges who were sentencing juveniles to incarceration and receiving a kickback. That'd be a wrongful conviction. It's very rare, though. But we monetarily reward someone who's wrongfully convicted, saying, okay, this shouldn't have happened to you, we're going to reward you. But you've lost time. You've lost years, and all we can do is give you money. Well, should prosecutors, judges, even jurors or defense attorneys be charged with some crime when they wrongfully convict someone? And if so, why or why not? Okay, there's those learning objectives. You can take a look at all those. They're really overall what we're trying to accomplish here, but Nothing critical for you to know going in. Okay. Some of this will refer to the Constitution. I will make some references to the North Carolina Constitution and North Carolina law as well. So let's talk about speedy trial. The Constitution of the United States, it has a Sixth Amendment, part of the Bill of Rights. Not routinely cited by people, but it says, at least in part, the accused shall enjoy the right to a speedy and public trial. Now, I didn't talk about public trial, but you don't have trials in secret. Now, we do keep the press out sometimes. They can't broadcast a trial necessarily. Sometimes they do. Most famously, we just had the Amber Heard and Johnny Depp trial. That was a civil trial, though. The speedy trial is a little bit more difficult. What do we mean when we say speedy trial? And again, as I've told you in previous chapters, the U.S. Constitution gives these rights, but it does not, on its face, give you an explanation of what speedy meant. There's no asterisk that said speedy must be within 24, 48, 72 hours. It must be in a week, a month, 10 days. At the statutory level, there's no federal statutory speedy trial right, but in North Carolina there is. North Carolina General Statutes 15-10 guarantees the right of speedy trial. A couple quick things here. It's kind of unusual about North Carolina. At least one I'll throw in. North Carolina has no statute of limitations for felonies. If you're talking about how fast you go to trial for committing a felony, in North Carolina you could have committed a felony 50 years ago. You could be in a nursing home and the police could come up and say, okay, it's 2022, 70 years ago when you were 20, you robbed a bank and we now know it's you and you're under arrest. North Carolina has no statute of limitations for felonies. Many states do. Some states have overturned those recently. Some of the child abuse and exploitation cases have resulted in states re-examining the statute of limitations, but North Carolina does not have one. Delays are very common in trial. There's, of course, two sides to every trial, the prosecution and the defense, and it has been known to both sides to delay a trial. The prosecution might delay it because they think their chances of getting a conviction will go up, or the defense might. And these can be very cynical reasons, like there's a sick witness and maybe they'll be unable to testify if we delay trial long enough, and we might win. Or the prosecution might be saying he's sitting in jail because he can't make bail, so the longer we delay trial, the more likely he's going to cut a deal. Delays, again, are very common. If you are looking in North Carolina, if you came to me and said, I want to go to trial here in Wake County and I want to go to trial pretty fast, and it's a serious felony, we're not talking about a simple parking ticket or something, you're probably looking at least a year before you go to trial, at least. And for a very serious crime where you're represented by private counsel and there's lots of motions, it could be 2 years for something like that. Delays then, very common. And if one side or the other delays, or if both sides delays, speedy trial is not triggered and there's no violation of the Constitution. All right. The Fifth Amendment of the Constitution guarantees you the right against self-incrimination, and in part, because there's more to it, it reads, no person, a little bit in between, shall be compelled in any criminal case to be a witness against himself. Now, obviously that should jump out at you. First of all, that modifier there, criminal case. If I am suing you civilly, you do not have the right to remain silent, assuming it's not a crime. You have to testify in civil cases. If you are called to the witness stand and you do not want to testify because you feel that what you say could reasonably be used against you and put you in jail or get you charged with a crime, you can claim the Fifth Amendment. Most recently, this last week or so, we've had the January 6th committee, and they were interested in Professor Eastman, who is a law professor, who came up with a rather novel theory that the vice president by himself could simply declare the President of the United States still in office. He could disregard the election. There is, by the way, no no evidence that that would be legal. And he was afraid that if he had to testify in front of the committee and was compelled to admit that he was offering basically advice to stage a coup d'etat and violate the Election Law Act, that he would be opening himself up, this is Professor Eastman again, to criminal prosecution. So he said, I will take the fifth upon the advice of counsel. Now, a couple quick things here. One, if the prosecution sees you take the fifth, they can't go to the jury and say, oh, if he was innocent, he'd tell us what was going on. They cannot argue in a courtroom that your exercising of the Fifth Amendment is an admission of guilt. There can be pretty good reasons why you exercise the Fifth Amendment. Maybe you were doing something inappropriate. Maybe you were committing a minor crime and you don't want to confess to that, and they charge you with a major crime. If you are granted immunity, because sometimes what can happen is, particularly in conspiracies, the prosecution will say, okay, we will grant you testimonial immunity or complete immunity. There's two types of immunity. More on that if you take our court evidence and procedure class. If you have this grant of immunity from the prosecution where they promise they will never prosecute you, then you no longer have a Fifth Amendment right, because there's no danger that you could be a witness against yourself, because there's no more crime. Presumption of proof and standard of proof. Okay, so in theory, a suspect is presumed innocent. Now I have to say, in my opinion, and again, this is something you should question yourself. You can clearly have a different opinion. In theory, a suspect's presumed innocent. In fact, a presumption of guilt seems to apply for most juries and judges. They do tend to convict. Now that can simply be because most people who go to trial are guilty of a crime, but we do have somewhere around 10%, we think, at least if we look at DNA evidence, of people wrongfully convicted. So if there's this presumption of innocence, it doesn't seem to be working too well. We also have a standard of proof. How much proof do I need? Now, I might have a suspicion someone did something. I might have some facts someone did it. But how certain do I have to be of my facts to be able to say they're guilty? So the standard in a criminal case is beyond a reasonable doubt. You have to offer proof beyond a reasonable doubt. Now, that is not higher than that, which is there can't be any doubt he did it. And it's not just a little bit of suspicion, which is sometimes called probable cause. You can articulate a suspicion that someone is likely to have done it, or even the civil standard of preponderance of the evidence. In theory, again, this is a pretty high standard, beyond a reasonable doubt. However, as there is a bias for the prosecution, it's not as difficult to meet as you might think. All right, the jury. Again, this goes back to the Sixth Amendment of the Constitution. Also, there is, and I'm not going to cite the North Carolina Constitution, but it's in the basically the first part of the North Carolina Constitution, although we just amended it. The Sixth Amendment guarantees you the right to a jury in criminal trials. Now, does this mean that all trials have juries if they're criminal? No. First of all, you're not going to get one for an infractionary charge like a speeding ticket. You're not going to get one for misdemeanor. If you don't have a jury, it's called a bench trial, because there's just the judge, and the judge is sometimes kind of goes back to the old bench, but the judge is the bench. Okay, so he will handle all the powers that the jury has. Remember, the judge decides matters of law. What is and isn't admissible evidence? What is and isn't permissible testimony? What is and isn't proper procedure? That's all technical legal. The jury decides the fact. Did the person do this thing? Now, if there's no jury, the judge wears both hats. He both rules on law and he rules on fact. So where do we get the jury if we want one? Well, the pool of possible jurors is called the venire. And back in the bad old days, particularly here in the South, during Jim Crow, where you had overt discrimination, juries tended to be all white and all male. So obviously there was a built-in bias there today against any minority, and often against women. That's changed thanks to several Supreme Court cases. The states have to use larger lists. So one of the ways in which we get a jury pool, the venire as it's called, is you get all your registered voters and you get driver's licenses. And other states use more lists as well. And you can see that that would be more egalitarian. It's still going to be skewed a little bit, but not as badly. So you're going to have 12 people typically on what's called a petite jury. P-E-T-I-T-E, petite, as opposed to a grand jury. First of all, they have to be impartial. They can't be favoring one side or the other. They have to be U.S. citizens. Generally, they cannot have felony convictions, although they certainly can have misdemeanor ones. They must be healthy enough to attend trial, understand what's going on. They have to be able to read and write and understand English, because the trial, of course, will be in English. Now, most states require that it be a 12-0 vote. North Carolina does. A few states allow supermajorities like 9-3 or 10-2, but that's the rarity, and it's never true for capital crimes. All right, here's a piece of bad Latin, and this can be pronounced any number of ways you want. I've heard it pronounced many, many different ways, and that's in part because our pronunciation of Latin has changed dramatically. One of the things that happened to Latin, not here, is that initially we didn't pronounce the C in Latin the same way that it was pronounced in the Roman times. So, for example, Julius Caesar is how we say the word. The Romans would have had a hard K sound, a K, so it would have been Julius Caesar. That sounds weird to our ears. So, how do I pronounce this word? Well, you can pronounce it voir dire, voidire, voidiri. I've heard all three. But what it means literally is to speak the truth. So you are going to, each attorney, both the prosecuting attorney and the defense attorney, are going to question jurors. They are going to say, okay, tell us what you know about the trial. Do you know anybody in the case? Yeah, it's my brother on trial. Well, you can't make a fair decision, so we are going to prohibit you from testifying. That's pretty common, that you would exclude anyone. We call excluding someone because they have an interest in the case, excluding them for cause. So if there's any reason you would be prejudicial, or you have a connection to the case, you're the brother of the prosecuting attorney, you're the sister of the judge, that would be enough to keep you off. There's also a number, and the number varies depending on how important the trial is, but you could take a number like 6 is probably a fair number. Each side, the prosecution, the defense, and remember, both of them question the jurors, will have a number of times they can simply say, I don't want this guy in the jury, or I don't want her in the jury. And that's called a preemptory challenge. Now, the prosecution can't exclude jurors because of their race or gender, but the burden is on the defense to show that any preemptory challenge, anytime the prosecution kept someone off the jury because they just challenged them, was racially motivated, and then I can ask for a new trial. And sadly, this does still go on. Now, prosecutions can use preemptory challenges to seat all white juries. Isn't that a contradiction of what I just said? No. It's not. You have to show when I did that, I was prejudicial. They do it. Neither can a jury be stacked with women or men to gain favorable jury. And this is J.E.B. versus Alabama. It's 1994 cases. But as I said, it's very difficult to prove abuse. Now, the case is Batson versus Kentucky. And if you take our constitutional law class, we'll spend some time talking about that case. But it has a 4-part test to determine it. And I'd like to be able to say, well, we've largely solved this problem. We simply haven't, because it's had a very little limited impact. All right, the trial. Let's be honest. Most trials are won or lost before they start. And that comes as a surprise to some of my students. But I tell them, when I was practicing, I would win or lose my case very often depending upon what motions I made before, because what you're trying to do at trial is shape the before trial is shape the trial. So if I can, let's suppose that I'm a defense attorney and there is one particular witness that is very strong for the prosecution, and I find out that he was inebriated and that he was delusional sometimes, and I make a motion that his testimony is excluded, that he's not allowed to testify because it is not competent testimony. Now, I'll do that 6 months before the trial starts. The judge will then hear motions. Sometimes they'll have arguments about it, and the judge will rule, yes, they can testify, no, they can't. Now, you can see how that would change the trial. If that's the star witness for the prosecution, all of a sudden they've lost a big part of their case. On the other hand, if it gets in, my guy's in trouble. So all of a sudden I have to maybe think about a plea bargain more or take a different strategy. So you're going to frame what evidence is and isn't admissible. I might make a motion that you should exclude this evidence because it was legally seized. I might decide what witnesses may testify, or, and this is very important, you can limit what they can talk about. You know, very often we don't let people who aren't experts state their opinion. Very often you do this with motions to suppress, motions to dismiss, or motions to restrict evidence. All right. The first thing that goes on at trial is opening statements. And the order that goes in is first the prosecution goes, then the defense goes. So the prosecution basically outlines its case. It says, let's suppose our defendant's name is John Doe. This is John Doe. He is charged with, we'll say, first-degree burglary. We're going to prove that he broke into Jill's house, that he entered the house, that when he went into the house it was nighttime, that he was not invited into the house, that he broke into the house with the intent to commit a felony therein. Specifically, he was going to rob her safe that was in the house. This gives the jury, or the judge, if it's just a judge, an idea of the prosecution's case. And he'll often say, I'm going to call these witnesses and I'm going to present this evidence. Now it's the defense attorney's turn. Now we stand up and one of the things I said is you theoretically have a presumption of innocence. You may want to hit the jury over the head with this. You may want to say, hey, everybody, remember, my guy's innocent. He doesn't start off having to prove anything. All the burden of proof is on that side of the room. The prosecution has to prove these things. If they prove some of them but not all of them, that's not good enough. They got to prove everything. And they don't just offer a little proof. They have to offer proof beyond a reasonable doubt. Now, these can be very standardized openings, or they can, because if you might be handling a lot of cases and you might have a kind of standard opening you use, or it might be very specific to this particular trial. All right, now we're going to have evidence. And what you've got over there to the side is the North Carolina Rules of Evidence from 2021. Not all evidence is admissible. It must be material, it must be competent, it must be relevant. So that kind of got caught off there to the side, but I want to emphasize that. Relevant, competent, and material. These are the rules for admission. You can see it's published. And there are two broad categories. There's witnesses and real evidence. So real evidence can be relevant, competent, and material. And what's that? Relevant means it matters in the case. It has some impact. Material means it's not just a little tiny thing. It's important. And competent means we can trust it. So all this has to be met. And if it's not met, you make a motion to exclude. So there can be direct evidence. Direct evidence is evidence that by itself proves something important. Let's go back to our burglary. We need to prove that the suspect broke and then entered as the two parts of burglary. So direct evidence, here's the window is broken, or the window's open. That's breaking as well. And we have to prove it was at night. How do we prove it is at night? Let's suppose it was 10:30. Well, I can say, what time did you arrive at the scene of the crime, officer? We got there at 10:30 p.m. And what day was this? It was December 25th, Christmas Day. Okay. Well, we all know that by 10:30 p.m., that is circumstantial evidence that in fact it is night. So you can have direct evidence. I saw Fred shoot Barney with my own eyes. You can have circumstantial evidence. I heard gunshots, walked in, Fred was standing over Barney, he'd been shot. You can also have prejudicial evidence. This is evidence that inflames the emotion of the juries and does very little to prove something in the case. Prejudicial evidence can be excluded. So, let's suppose you've got an unpopular political, ethnic, racial, religious minority. I don't care. Make up a fictitious one. Let's suppose you've got albino Eskimos who are transgender and worship Zeus. Okay? And everybody in this jurisdiction hates Zeus worshipers or hates albinos or hates Eskimos. If you are introducing evidence to show that this person is one of those just for the purposes of inflaming the jury and not proving something important, then that's prejudicial and we can keep it out. The prosecution's case is to establish the corpus delicti, the body of the crime. They have to meet each and every element. I think I have the burglary in a second here. Typically what you do to start as the prosecution is you're going to do direct testimony. Now, direct questioning is basically story time. What happens is you call the witness and you say, what happened on December 25th? And the witness tells you. When you're done, and that evidence is in the record now, and maybe there's a motion to admit evidence. Did you take a picture? Yes, I did. Is this the picture? Yes, it is. Motion to admit this, and it gets admitted. Excuse me. Then the defense, or if this is the defense case and the prosecution goes second, then the defense gets to cross-examine. And this is vital. This is absolutely your right under the U.S. Constitution to cross-examine, because the ability to ask questions about a story often will prove it's true or false. Anybody can tell a good story. People have told great stories about seeing UFOs and Bigfoot and ghosties and poltergeists and all these weird things. The problem with most of them is if you start to ask them questions on cross-examination. So you say you saw Bigfoot, right? Were you drinking? Well, yes. How much were you drinking? I was on my second six-pack. Well, now I'm kind of doubting you saw what you thought you saw. Do you wear glasses? Yes, I do. Were you wearing them at the time? No, I wasn't. Okay, so you were drunk and you didn't have your glasses on. Was it daylight or night? It was night. Were there any lights? No, there weren't. How far away was the Bigfoot you saw? 80 feet. And you're nearsighted? Yes. Okay, so basically I've shown through cross-examination he was drunk, without his glasses, no light, at night, and saw a blurry object. Cross-examination there destroyed his direct testimony. So, cross-examination, Sixth Amendment, you shall enjoy the right to confront a witness. Critical because, again, you can tell any good story. Now, when I talk about telling stories, this brings up hearsay. Hearsay is you heard something and now you're going to repeat it in court. So, quick example here. You are the witness to a homicide, and you hear the defendant say to his wife, I'm going to kill you for that. That's pretty chilling, okay? And you're repeating it. And maybe he said before it, I'm going to hit you. And she dies of a blow to the head. Okay, wow, very chilling. But do you repeat the exact tone of what you heard? Did you hear it accurately? Think about the word hit and think about the numerous ways hit can be used. Let's suppose they were playing blackjack and he said, I'm going to hit you. Let's suppose they were kidding. Let's suppose they were just, I could hit you for that. there are so many different ways you could have heard that. And maybe you heard a voice, but you can't even show it was the husband's. So hearsay is theoretically inadmissible. You don't get to repeat what you heard. But, and this is the big but, there are at least 24 exceptions to the rule that hearsay is inadmissible. What that means is most of the time, you can find some way when someone tells a story to get it in and make it admissible. Okay. Prosecution rests, now it's the defense. And one of the things the defendant's going to do at this point is, I would typically make another motion to dismiss the case because they didn't prove something. And those are almost always denied. But let's suppose the prosecution was supposed to prove this burglary occurred at night. And in fact, they offered no evidence. They didn't say what time it was, that the case occurred at night. They closed their case, it's my turn, I'll stand up and say, I'd like to make a motion that the charge is reduced from first-degree burglary, which has to occur at night, to breaking and entering, or second-degree burglary, because you didn't even prove someone was home. You could then reshape the trial a little bit. So in theory, the defense doesn't have to offer any case. You can simply say, hey, I poked enough holes, I'm done, I'm sitting down. Practically, though, you got to create reasonable doubt, exposing a hole, a lie, a mistake, or something that's not truly there but is important, a lack of a motivation. You also have defenses we talked about in the early part of this course. You might offer an alibi. You might claim that your client acted in self-defense. You might claim there's an insanity issue, that there was an immediate physical threat or duress, or that he was entrapped in committing the crime. Now, after the defense gives its case, the prosecution sometimes can give what's called rebuttal. So let's suppose I offered someone to testify, and they said something that was important that the prosecution hadn't been allowed to bring up during direct because I didn't know whether it was going to offer it or not. At that point, they would have the right of rebuttal, which means they could call another witness or recall a witness. When they're done with that, I would actually get what's called surrebuttal. These don't happen very often because most of the time the court isn't that formal and isn't that structured, but they can. Okay. Defense rests, prosecution rests. Now we do closing arguments. The defense goes first. They went second on the opening, but they go first. And generally what you're going to argue as the defense is they didn't prove their case. Either they didn't meet the standard of proof beyond a reasonable doubt, or they just blew it. The prosecution is going to argue they did meet their case. These are their closing arguments. Now they can only argue those facts that have been admitted to evidence already. They can't add new stuff or bring new stuff in. It's very limited. Each side argues to the jury, if there is a jury, or to the judge that their guy is either innocent or guilty. All right, now the jury gets to go back. Now we're assuming again that there is a jury. It may just be a judge. If it's a bench trial, it's just a judge involved. One of the things that happens is the judge has to give them instructions. Okay, these are the elements of first-degree kidnapping, right? A, B, C, D, E. You've got to find that each one of those is present to get a conviction for first-degree kidnapping. If you don't, you might have an alternative instruction of second-degree kidnapping. That's these crimes or these elements, A, B, C, D. So the judge gives these instructions, and he tells them, your jury verdict has to be unanimous. You all have to agree what's going on. Jurors then go back and they deliberate in secret. Nobody knows what goes on in that jury room. Nobody's sitting there except the jurors. What can they consider in the jury room? Well, the jury is only supposed to consider that evidence that's admitted in court. Now, they can obviously use some common sense, but they shouldn't say, well, I visited that intersection where they said the accident was, and I measured off the distance myself, and the prosecution was wrong. It wasn't 40 feet, it was 80 feet. Can't do that. That's not in evidence. You're assuming stuff not in evidence. It's grounds for a recall. The verdict is either generally going to be guilty or not guilty. Now, if the the jury cannot reach a verdict if there's a vote, and if it's 12-3 to convict, or 12-3 to acquit, or some number, 6-6. It's called a hung jury. No verdict was reached. So, if there's a hung jury, that essentially waives double jeopardy. You can have a retrial. Now, those are fairly rare. They happen in only about 6% of felony cases. So, 94% of the time, you're going to get a verdict. Jury nullification I'm going to mention now. And jury nullification kind of has two sides to it. It has kind of a negative side, a kind of ugly side, and it has kind of a positive side. So again, I talked about Jim Crow a little bit in the past, about selecting jury pools that were all white and all men, tended to convict, primarily in the South, blacks, but also women of crimes they didn't commit. A jury nullification is when the jury goes back to the jury room and says, yeah, I heard all the facts, but true justice is we should acquit this guy or convict him. So take this scenario. A man is accused of killing the person who raped and murdered his child. And that guy was about to get off on a legal technicality. And there's actually a movie, John Grisham, I think it was Presumed Innocence, License to Kill, something like that. I forgot what it was. That was very similar to this. So a guy's going to get off from a murder charge. The father of a murdered child kills him. And the prosecution wants to charge the father with first-degree murder and sentence him to death. And that's the only option they give you in the jury room. And you're sitting in the jury room and saying, if the prosecution had given me manslaughter or some punishment, I might have voted for it. But it's really not just to give him the death penalty, so I'm going to vote to acquit, even though the facts are there that the father actually killed the suspect. All right, well, that's not the worst thing in the world. Where you see it most commonly is where a prosecutor is going after someone for a simple possession charge, say marijuana, and the jury says, this is a waste of time, I don't believe that drugs should be illegal like this, I'm not going to convict. They just refuse to convict on simple drug charges. All right, you can kind of understand those, but let me give you an evil side to it. Again, you have an all-white jury, and a white man is accused of killing a black man. He clearly did it because he just racially hated the black guy. The jury goes back and says, well, we're just not going to sentence a white guy to death for killing a black guy. We're going to acquit him. That's jury nullification. There's nothing you can do about that. Now, the interesting thing is, as a defense attorney or the prosecuting attorney, we can't tell the jury they have this power. They have it. They can do it. It's well established. But you can't tell them they have the power at trial. All right, a little bit about appeals. Appeals can come from trials or from other appeals. In other words, I appeal to the North Carolina Superior Court from district. That doesn't happen too often. Let's suppose I appeal from a felony conviction in Superior Court to North Carolina Court of Appeals. I lose that appeal. Now I can appeal again. I can appeal to the North Carolina Supreme Court. So usually what you do, but not only, there are others, it's called a writ of cert, a few things. You can file a writ of habeas corpus. And what you are going to argue, and this is where most students don't understand, is you are not going to argue you're innocent. In fact, you almost never can argue that. What you have to argue is that the judge made an error of law. He admitted evidence that he should not have admitted, and that impacted my conviction. So you don't appeal based upon the facts of the case themselves. You appeal because there was a mistake of law. And again, most appeals are not successful. They're only successful about 10% of the time. This rather convoluted flowchart is pretty much the North Carolina criminal justice process, including appeals and stuff. And particularly the bottom there is the appeal. So you've got your felony arraignment, your Superior Court trial. Now you got an appeal to the Court of Appeals. Dismissed or remanded. You go through the whole cycle again. Affirmed. you got another appeal, North Carolina Supreme Court. And by the way, of course, it's not just limited to this. You could, in theory, go to the United States Supreme Court, which is the biggest of the big dogs, jump outside the North Carolina legal system. All right, I had mentioned this very briefly, double jeopardy. Again, this is one of those constitutional rights, a Fifth Amendment right. There's a terrible movie with Tommy Lee Jones, and I forget who it was about it, which got the law completely wrong. But basically, the Fifth Amendment says, nor shall any person be subject for the same offense to twice be put in jeopardy of life or limb. What does this mean? If you have a trial and the trial goes to conclusion, in other words, the jury comes back with a verdict, guilty or not guilty, that's it. If the prosecution can't appeal a not guilty verdict at trial. Neither can they appeal a guilty verdict at trial. At that, only the defense can. Okay? No defendant appeals a guilty verdict, a not guilty verdict. You only appeal guilty verdicts. After I appeal once, okay, then I am waiving double jeopardy. If you're guilty, okay, only the defendant can appeal. If no verdict is reached, double jeopardy doesn't attach and we can have another trial. So let me give you a quick example. Let's suppose a defendant, John Doe, is found guilty. His defense counsel appeals. It goes to the North Carolina Court of Appeals and the defense wins. Now, that means there can be a new trial. Or the prosecution can appeal to the North Carolina Supreme Court and they might uphold the decision, in which case there's no new trial. But when you appeal as defense counsel, you do waive your constitutional rights against double jeopardy. All right, now we're going to talk about we're going to take 5 minutes or so and talk about a few ramifications of this, a fairly contentious part of wrongful conviction. What happens when someone who is factually innocent goes to jail? Now, based upon DNA alone, where there's appeals because someone was convicted and they go to jail and they continue to appeal, okay, 12.6% of felony convictions are wrongful. That's a pretty scary number. And the reason I want you to think about that number, of course, it's first of all, if it was 100 cases, don't think that means that 12 of those cases going to trial, we get it wrong. If you've got 100 DNA cases, it's not 12 of those are wrong. It's those cases that people appeal. So probably, let's say, of that 100 cases, 50 of them, nobody appeals their conviction because they lost. There's no sense to appeal. Okay? So they're not even going to show up. So of the remaining 50, if there was a 12% wrongful conviction, that would mean out of the total 100, only 6 were wrong. So the number is a little misleading, but it's still a scary number. What it does mean is that when someone actually appeals and there's DNA evidence, about 1 time out of 10, they're innocent. That really goes to show you that our legal system's not perfect. And of course, that raises a whole number of questions. First, what are the reasons for wrongful conviction? So I listed some there that your book talked about and some that I threw in. Misidentification. This is probably not as shocking as you might think, but this is when someone identifies someone as the criminal, so a victim or a defendant identifies them and says, that's the guy that did it. A witness says it. And they're wrong. So why are people wrong? Because people don't have cameras in their heads. They don't really... You're remembering what you remember. You're not actually re-seeing something. Second one, faulty forensics. This happened in North Carolina not too long ago here in Raleigh, where we had someone that was worked at the state forensics lab. He was a blood expert, and he simply did bad tests. He was a really incompetent technician, and a lot of his tests where he said, yeah, this guy is the one that did it, were just wrong. So sometimes the science is wrong. And again, if you don't have access to someone to independently check, and remember we told you that the prosecution controls all this, so it's just going to be that one test. That can be a problem. Okay, police misconduct. The police can misbehave. And that can lead to any of the following here. False confessions. Surprisingly enough, I'm going to look at a case in a moment. Surprisingly enough, people will confess to crimes they didn't do, and the general public cannot understand this. And I think a lot of it is because they have never been in a situation where they're terrified and where a person in authority says, look, things are going to go so much better if you cooperate. I'll talk to the DA for you, or things will go better. And we want to reach out and we want to believe. And we say, well, even if I didn't do it, I guess I'll confess. And people do confess. False informant testimonies. This is somewhat notorious from jailhouse informants. I've talked about it before. The police ask someone if they did it. They refuse. They say, okay, we're going to put you in this jail cell. In the jail cell next to you is someone that's an informant for the police. Very often this is a person that's been arrested for a criminal charge, and the police say, if you get the guy in the cell next to you to confess that he killed someone, we'll drop the burglary charges against you. So lo and behold, the burglar says, oh yeah, he confessed to me. Even if he didn't, you can see where the incentive is there. And then of course there's prosecutorial misconduct. Prosecutors that hide evidence, prosecutors that submit evidence they know is false because they want to get elected or reelected. We had a fairly famous case over in Durham, the Duke lacrosse case, where you had egregious behavior by a district attorney. Okay, overall then, about our 50 minutes again, I think we did okay. When you get a moment, reflect on some of what we talked about. Maybe do a little independent research. Maybe come up with some ideas. And hopefully I'll see you in class. If not, have a pleasant morning, afternoon, evening, or weekend. When you're ready, start Chapter 11.